Now, I'd like to ask Ruth Garby Torres to present to the group. Thank you very much. Big warm welcome to Ruth Garby Torres.
Thank you. Borrowing from Earl, also, I would have had my disclaimer up here, but I wanted to save some time. I'm sure in my introduction and in the bio that's in your materials, you'll see that I am not a lawyer, a legal scholar, a law student, any of those things. But if you take a peek at my bio, you will also see that I have, well, it doesn't say how many, but I had 21 years of law enforcement. Oh, I'm sorry. I had 21 years of law enforcement experience, so I know something about some law. I was a student of public policy and still am public policy and community organizing in order to understand how we as citizens can get agreeable working policies that affect our lives and how to engage as constituents and how to understand the power that we have as constituents. When I retired from the state police to attend grad school, it was to learn how to do this and for my own and other communities. We have one of STN's former attorneys in the room, Judy Shapiro, who you heard just before us, as well as our professional anthropologist, Steve Boston. Judy, for sure, can give you a legal rendering of the Schaghticoke legal experience, and I'm sure she will answer any questions that you would like. I have included in the materials just, and this thing isn't as long as it should be. Here we go. I've included in the materials on page 291 just a list of documents that contain a lot more information about the Schaghticoke experience. These are court orders, motions, and the like that document the whole experience pretty much with my tribe's path through the federal acknowledgement process. Also on the top of that page are some dates that are important. I think one of the most important ones are when we first filed our letter of intent and when the Indian Gaming Regulatory Act was passed. Contrary to popular belief, the notion that tribes filed for federal acknowledgement in order to have casinos because there was a law that would allow it. Most timelines on petitions would show that is incorrect, including ours. Also, if you do want to know more about the Schaghticoke experience, and here's the shameless book plug, on the back of that page on 292 is the cover of a book that was recently released and mentioned in my intro, and I want to acknowledge one of the co-editors of the book, Dr. Amy Denowden from UMass Boston, who I would also like to include in praising with the Eastern Pequot Tribal Nation, who sent her as a delegate to sign off on the declaration today. In a true move of sovereignty, they allowed a non-tribal citizen, a non-tribal person, to sign off on their behalf and in support of this declaration. So I commend Eastern Pequots and Dr. Denowden. Let me give you a little information specific to the Schaghticoke experience. From our letter of intent until the reversal of our acknowledgement, the Schaghticokes were involved in the process and the available administrative appeals for 24 years. Before we filed our letter of intent, we had sued the Kent School, which is a private school for affluent students, for dispossessed tribal lands. My understanding is that when we had an issue of standing in the federal court and were advised to come back when we were a federally recognized tribe. And this is surely an oversimplification on my part. Regardless, as our tribe began to understand the potential costs of the required historical and legal research, as well as for the paid expertise we would need so this litigation could go forward, it became clear that we needed financial assistance. As a mere tribal citizen, I'm not privy to how my tribe contracted with the owner of the Connecticut-based Subway restaurant chain, Fred DeLuca, and his partners in the group called Eastlanders. In the late 90s, when we agreed to pursue a gaming enterprise through 2010 with an unsuccessful motion to the U.S. Supreme Court. Eastlander invested approximately $22 million in our process and the ensuing appeals. And so Schaghticoke has us beat in the way of debt, but certainly we're in the same boat. Our land claim litigation often impacted the process, and to the detriment, dismay, and delay of other petitioners, likely Schaghticoke, the bar, or OFA, was ordered by the court to expedite consideration of the Schaghticoke petition. We moved ahead on the ready for consideration list a few times over the years. And what I'm going to talk about more specifically in our case is what I consider to be a pretty well-documented case of political influence on the process. Doing research for the chapter that I eventually wrote, I tried to zero in on the exact date when outside political forces started to exert their influence on the Schaghticoke's petition. What I found by creating a reverse timeline, much of what I was doing was more or less as an investigator, because that's what I brought to this, was that the events and outcomes were not linearly arranged, but there were multiple layers of special interests working together at times or singularly within their own spheres of influence, all moving along in the same direction with the same goal to make sure that the Schaghticokes would not be recognized. The political players did not always have the same motivations, but the outcome would satisfy all of them. For the town of Kent, where our reservation is located, the threat of a sovereign entity outside their control certainly weighed in on their fears, and as well as having a gaming facility near this rural community. In May 2004, I attended an informational meeting on the issue of recognition of the Schaghticoke Indians in the town of Kent. And I have my notes that I looked over from that day recently, and my own editorial comments, which I tend to do when I'm listening to things that I need to vent about. And a sampling of the local sentiment that was of that day was a statement made by an elderly Kent resident who was sitting in front of me. And he said to one of the other residents next to him, "I want people to have the same values as I do. When they talk about diversity, well, they're talking about diversity, not me." For sure, changes to the status quo and the fear of the unknown alarmed many Kent residents. The informational meeting was just one day after a House Committee on Resources Oversight hearing on the current reorganization of trust management at the BIA and the Office of Special Trustee. This meeting was just over a week after the state of Connecticut and local towns filed a request for reconsideration of our final determination, and Congress held a hearing entitled Betting on Transparency Toward Fairness and Integrity in the Interior Department's Tribal Recognition Process. Betting, it was called, Betting on Transparency. Now tell me, what do you think was the motivation for the political influence exerted on the FAB? If you guessed the potential for a third casino in Connecticut, you're correct. No evidence makes it more clear, at least more clear to me. For all the talk about a fatally flawed process, rules bent to the advantage of the Schaghticoke petition, and allegations that an internal briefing memo was the smoking gun that proved how corrupt the process was, no evidence makes it more clear that it was gaming and not fairness that produced the political strategies and outcomes in this. That once the Schaghticoke and Eastern Pequot final determinations were reversed, no one in Connecticut cared about fairness and integrity in the FAP at all. Going back to that informational Kent town meetings, there was a woman by the name of Nancy, and I didn't get her last name, but she was a select woman at the time, and she said, quote, "We weren't really concerned about the issue of federal recognition in 2000. Now, in my previous employment, that's what I call a clue." So without the benefit of internal communications from the Connecticut Attorney General's office, I've determined that the first strategies to wage a political influence war started not long after the Eastern Pequots received a positive proposed determination, which was March 2000. That summer, a research at the bar told the Connecticut Attorney General, "You may not like hearing this, but the best evidence supporting the Eastern Pequots' federal recognition comes from the state's own record, comes from the fact that the state has maintained and documented a continuous government-to-government relationship." The AG was later quoted, "We're going to be making a record that may well be before a court someday," describing his agenda for the meeting with Barr in Washington, August 8th and 9th of that year. This was according to a New York Times article. The Attorney General, who is now a U.S. Senator, told the Times that he was fighting the federal recognition of all petitioning Connecticut Indian tribes because of the added burden of traffic and law enforcement that Indian casinos put on neighboring towns. What followed over the course of the next 5 years was unprecedented pressure to reverse our final determination, in the words of STN's motion for summary judgment on our land claim. The motion argued that this pressure began on January 29, 2004, when 20-year incumbent Congressman Chris Shays of Connecticut publicly stated that the recognition would lead to another casino and that he would continue to work with the Connecticut Attorney General to get our recognition reversed. I still say it started with a whisper campaign of misinformation among local residents and municipal and state elected officials that gained traction when the untruths and exaggerations found public forums for further dissemination, and with the specific purpose of causing public fear. I can cite several historical movements that bordered on hysteria, but nonetheless resulted in changes to public policy and law, such as Prohibition, Red Scare, and McCarthyism. This political influence campaign started long before January 29, 2004, as many other negative events moved in concert with our petition up to its final determination. Much of this strategy was aimed at the Eastern Pequot petition as well. In early 2001, Congressman Simmons held a congressional field hearing on federal recognition and the Schaghticoke Pequot Settlement Act at the state capitol, while the Connecticut Attorney General and U.S. Senator Dodd were calling for a moratorium on federal acknowledgement decisions until the FAP could be reviewed and changed. Advanced copies of The Revenge of the Pequots were available during the field hearings, and a subsequent New York Times book review dovetailed nicely with growing public frenzy. The Connecticut General Assembly held 2 public hearings that spring, and a public hearing on a bill that proposed to amend the procedure of amending Indian gaming compacts. In June, after the Eastern Pequots received their final determination, then Governor Rowland weighed in on the state's policy on tribes, casinos, or both when he said, 2 is enough. The Connecticut General Assembly struck down the state's Las Vegas Nights law, and 2 members of the Connecticut General Assembly introduced a bill to terminate the Schaghticokes, Eastern Pequots, and Golden Hill Gussets, while creating a process with 7 criteria for us to petition for state recognition. That process looked an awful lot like the FAP, which these same 2 lawmakers insisted was broken. It was only after Schaghticoke's final determination that we saw a lot more political leveraging at the federal level. Borrowing again from the motion of summary judgment, quote, what followed was a coordinated political assault on the final determination, choreographed by various participants to focus on common themes that were designed to exert the most pressure on the department to undo the final determination and to disguise their true intentions by making it appear as if the concern was with the acknowledgement process and not the actual final determinations. The specifics of this political influence are contained in many of the documents, especially the 2007 motion for summary judgment and the 2009 brief to the Second Circuit Court of Appeals, which I listed on that page 192. Virginia Congressman Frank Wolf, with some of the Connecticut delegation, engaged Interior Secretary Gail Norton in what was described as an ex parte meeting on the Schaghticoke decision. Wolf told Secretary Norton that he would go to President Bush and tell him she should be fired. In fact, advisors in the White House met with Assistant Secretary of Indian Affairs Maureen Martin to discuss our federal determination decision. There were other ex parte communications by the Connecticut Attorney General, and our then Governor Rell wrote to Judge Dorsey, whose court was considering our motion for summary judgment, urged him to deny that motion and to extend and not to extend the scheduling order that he had created, and not to allow us to submit additional evidence. Although this political influence was well laid out in our various motions and briefs, the Second Circuit ruled that the evidence we presented was insufficient to raise a claim of improper political influence, and in 2010, Schaghticokes brought this matter to the U.S. Supreme Court, but the appeal was denied cert, and the Second Circuit's decision stands today. On my shameless book plug on 192 is my name, my email address, and my cell phone number. Being the somewhat anal collector of evidence that I can be, if anyone would like all of those documents burned to a CD, I'd be happy to mail that or get that to you somehow, rather than, if you're really interested in researching any of this or reading it, trying to find all of those documents yourself. So thank you very much.
think you've heard now a pretty fascinating and wide-ranging set of really interesting war stories and providing